5 seconds to go. Start. From the perusal of the records and the submissions of the parties, we observe that the mandate of the arbitrator was extended by an agreement between the parties. Thus, it can be construed that the parties had not agreed to the extension of the mandate of the arbitrator, failing which the mandate was automatically terminated. However, the contention of the appellant that the High Court had erred in not allowing the appellant to decide upon the appointment of an arbitrator pursuant to subsection 2 of section 15 of the Act must be accepted. In this connection, it would be appropriate to refer to the relevant portion of the impugned judgment of the High Court, which gives an elaborate observation on the above mentioned issue raised by the appellant. Arbitration is an informal, quick, and easy alternative mode of adjudication of disputes by agreement of the parties. This court clause was invoked way back in May 1996, and almost 10 years have expired since then. The appointment of successive arbitrator by the chairman cum managing director of the respondent has only resulted in delay. When the mandate of an arbitrator is terminated on the ground of delay, the rules applicable to the appointment of the arbitrator are to apply to the appointment of a new arbitrator. It would, however, be a mockery of justice if every time the mandate of an arbitrator was terminated or the arbitrator resigned or otherwise became unable to proceed, the parties were to start from scratch by invoking the arbitration clause. Once the mandate of the arbitrator terminates, the person required to appoint arbitrator is required to fill up the vacancy with utmost expedition, failing which the provision of section 11(6) of the 1996 Act would be attracted. In the instant case, as per the arbitration agreement, the chairman cum managing director was required to appoint a new arbitrator in case the arbitrator became unable to continue, whatever be the reason. A bare reading of the scheme of section 11 shows that the emphasis is on the terms of the agreement being adhered to and for given effect as closely as possible. In other words, the court may ask to do what has not been done. The court must first ensure that the remedies provided for are exhausted. It is not mandatory for the Chief Justice to appoint the arbitrator. Apart from the three accused whose presence at the place of occurrence was not accepted, the trial court also doubted the presence of two out of the three eyewitnesses. The trial court further held that even PW2, the only remaining eyewitness, had mixed up truth with falsehood, but his testimony was not liable to be discarded wholly, since he had himself received injury in the same occurrence. In regard to the injury, the trial court came to a truly amazing conclusion. The injury on the hand of Ramesh was certainly in existence and it was also proved by the medical evidence. The trial court resolved the contradiction by fastening the injury to Ramesh too on to the appellant, even though that was not the case of the prosecution. The appellant was thus held guilty also of causing the knife injury to Ramesh and came to be convicted under section 324 in addition to section 302 of the Penal Code. Under section 324, he was sentenced to rigorous imprisonment for 1 year. He was also convicted under section 25 of the Arms Act by a separate judgment of the trial court dated February 2, 1998 in Sessions case number 26 of 1993 and sentenced to the period of imprisonment already undergone as under trial. Against the two judgments of the trial court, 3 appeals were filed in the High Court. The High Court, by the judgment and order coming under appeal, dismissed all the 3 appeals and the revision and thus upheld the judgments of the trial court in all aspects. The senior advocate appearing for the appellant assailed the High Court and the trial court judgments and contended that the appellant's conviction for the offense of murder was not sustainable both in law and on facts. He submitted that there were at least 4 circumstances that falsified and completely demolished the prosecution case. First, there was a patent contradiction between the prosecution case and the motive assigned by it to the accused for committing the crime. Secondly, it was undeniable that injuries were fabricated both on the person or the deceased and Ramesh, the only eyewitness whose evidence was accepted by the High Court. According to the prosecution case, there was a fierce enmity between the persons of accused party and complainant party. Stop.